how do you trigger that notification? I'm a homeowner. I want to put a obligation on the board to turn over these records. Is this by way of email? Is it certified? Talk to me about the notice requirement, if any.
It's a great question. And I will tell you, I get asked that question a lot. And a lot of people say, why can't I just email my property manager for these records? And I would love to say, yeah, just send a quick email. The problem is, if you live in a condo or an HOA, the statute is very specific, whether you're in 718 or 720, that you can't just write an email. I wish you could, because a lot of people reach out to us and say they haven't given me records, and I emailed them and they're not responding. And I say, I wish I could make a t-shirt that says, I would like to get official records through an email. But unfortunately, that's just not the case.
I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of L.S. Carlson Law. Welcome back to the show. Today we have a very special guest, Jeff Kominsky out of Florida. He is the managing partner of our Florida operation, and he did a tremendous job last time he was on the show. In fact, I think he has some of the most views of all of our videos.
That is true. Of all the videos and the podcast, that one took the cake. A lot of good information on that one.
Great information. Sure. The market responded very favorable, and Jeff has some new updates. So, Jeff, welcome back.
No, thank you very much. I always like to say it's a team effort, and so maybe the three of us combined, kind of like our powers combined, made it such an informative video last time. So the hope is that we can kind of repeat it, if not do better, to make sure that everybody's informed. There's been a lot of interesting changes in the state of Florida when it comes to association law. Most importantly, a lot of new updates that became effective starting July 1st of this year in 2024. And this is kind of a third wave of implementing new laws in the state of Florida over the last consecutive years, based on a lot of unfortunate things that have happened in the state of Florida. So my hope is that we can get into that and make sure people are just informed about the laws and generally and know what their rights are.
Yeah, no, I love it. And ultimately, as I see this, and I think everyone would agree on the show, it's really to empower the homeowner. Because, they say it's a cliche, but it's absolutely true when it comes to these situations, is knowledge is power. And Florida is constantly, I believe it seems to be in a state of evolution, attempting more and more ways, or looking at more ways to really protect the homeowner. And the homeowner is not going to be able to leverage the laws, though, without the information, which I think this is a great platform. So with that being said, Jeff, do you just want to jump right in?
Yeah, absolutely. I think ultimately, as just by way of background, there's a lot of new laws that have taken effect over the last few years. And I do think there's been a seismic shift in making sure that property owners in Florida, condo owners, home owners, even cooperative owners in the state of Florida, now can get more transparency, now can get that the response that they believe they're entitled to get, especially because they pay good money in association dues, whether it's monthly, quarterly, yearly. I can tell you that it's really been interesting, especially with COVID happening in 2020. A lot of people moved down to Florida, became one of the biggest states of transactional real estate, people wanting to move here, people wanting to buy here, and then kind of trying to catch up on the back end and learning their rights after purchasing the property.
Yep, exactly.
So I'm definitely happy to go over some of the new laws, as well as, kind of make sure most people on this, whoever's viewing this, understand how these new laws and even the laws from the prior years in the last 2 or 3 years are greatly impacting them in either a positive or negative way.
All right. I love it. Let's dive right in. Where do you want to start, Jeff? Which one piques your curiosity or your interest?
Well, there were.
What do you want to focus on?
There was a variety of legislation that passed in July of 2021. There's at least 6 different either House bills or Senate bills that eventually became law. So we can talk about the House bills. Maybe if we start out with House Bill 1203. But there's other bills that we can talk about as well that ultimately became codified and actual law. So I do want to make sure that the audience knows that if we're mentioning House bills, you can research those on your own time, but ultimately the House bills, a bill becomes a law, and the law is not now called a House bill. It's now part of the statutes.
Sure.
So just so everybody understands, if you live in a condominium and you pay dues, you're most likely your rights are not only based on the contractual part of your rights, which are usually referred to as your governing documents, but also, most importantly, I usually refer to the declaration is one of the most important documents. And then there's bylaws. Bylaws is usually administrative. It talks about board member duties and responsibilities, election protocols, that kind of thing. Articles of incorporation is sometimes a third contractual document that's important.
Jeff, we're talking about CC&Rs is the first document that you were referring to?
Yeah, CC&Rs,
okay,
but I think it's important because we're going to go over the law. If we're talking about changes in declarations or bylaws based on statutes, I think everybody's got to know what we're referring to right out of the gate.
And just one point of clarity, because I see this at least in California. I believe you guys see it in Florida. You have homeowners, condo owners who are sitting in their new property and they say, well, I don't have these documents. Where are these documents? So what would you recommend? I mean, in California, at least they should have received them at point of acquisition of the property. But if that didn't happen, just first step, fundamental step, if you don't have these documents, where can someone procure the documents?
So that gets into what some of the very significant changes have been in starting July 1st and last year. And there's two bills to think about. It's House Bill 1203 and then House Bill 1021. Okay. Both bills affect either a condominium or a HOA. If you're a condominium, your statutory rights are based on Florida Statute Chapter 718. That's the Florida Condominium Act. And if you live in like a single family home in an HOA, you're most likely under what's called the Florida Homeowners Bill of Rights. And that is specifically Florida Statute Chapter 720. To answer your question, how do you get some of these documents? The laws changed in those 2 bills that I just mentioned as it relates to the statutes 718 and 720. If you're in a condominium, you can get access to official records through using a statute that you most likely have under 718.111. Florida Statute 718.111. It's a pretty long statute. But the portion that's important is that you can get access to, quote, official records of your association. And official records are generally defined as any written records that relate to the operation of your association. This law has existed for years. But what really makes it interesting and what really gives it some meat on the bones now is that the Florida legislature found that there needed to be more significant documents and more penalties if there were official records that were not provided. So now the statute has changed starting July 1st, that if you live in a condominium association, you can ask for a whole host of documents that you couldn't have asked for before then. For example, one of the things that we see happening a lot are structural records and structural integrity reports. Because what happened a few years ago in Florida was the devastating tragedy of Surfside, where in the Champlain Towers, almost 100 people passed away. And it was determined that the board hadn't acted before because they didn't want to impose special assessments. There are various allegations and there's a lawsuit that I'm not going to get into. But long story short, the result of that lawsuit prompted the Florida legislature to make sure that there was more transparency. And the way to create more transparency is to give access and better access of certain records to individuals who really want to understand what they're getting into when they're living in a condominium association. So not only are there new records that you can seek, but it's also the law has changed and stiffer penalties if the association does not give you records. First off, they have to give you access to records within 10 business days of the day they receive your written request. In legal time, this is supersonic fast, okay? And you need to understand that this is very helpful to not only know that they respond to you within 10 business days, but they have to respond, tell you an inventory of the documents where they're at, if there's like a association website or portal, or they have to tell you, well, we have these records and they're at our office, so you can come into the office within that same 10 business day period.
Jeff, briefly, because I like practical knowledge that a viewer can actually say, yes, I understand this, but how do you trigger that notification? I'm a homeowner. I want to put a obligation on the board to turn over these records. Is this by way of email? Is it certified? Talk to me about the notice requirement, if any.
It's a great question. And I will tell you, I get asked that question a lot. And a lot of people say, why can't I just email my property manager for these records? And I would love to say, yeah, just send a quick email. The problem is, if you live in a condo or an HOA, the statute is very specific, whether you're in 718 or 720, that you can't just write an email. I wish you could, because a lot of people reach out to us and say, they haven't given me records. And I emailed them and they're not responding. And I say, I wish I could make a t-shirt that says, I would like to get official records through an email. But unfortunately, that's just not the case. So in order to trigger the statute, to use your rights effectively, you really need to go through a 3-step process. This is something we can do, but just to help everybody out here, if they want to try it on their own, really it's sending a certified letter to your association's registered agent. And then in that letter to the registered agent, you need to identify the statutory right that you're using, like an official record statute right, and then identify the specific records you want access to. And that's where the statute is critical, because the statute, whether you're in a condo or an HOA, identifies all these specific records that you are entitled to. But before you do that, my first thought would be to go and see if your association has a website or a portal, because you want to see, why would you ask for something if you know you already have access to it?
Right, if you have access to it directly.
And a lot of...
Oh, sorry.
Sorry,
Jeff. Before we get, I don't want to get too far down the rabbit hole. Just one quick thing. You mentioned agent for service of process. Could you explain how a homeowner or a condo owner could find the agent for service? Because I think that's a little point. You know, it's very granular in nature, but it's pivotal. It's absolutely pivotal.
The same thing.
Yeah. What is a registered agent? Well, that seems like a pretty interesting legal name. So it's very simple. A registered agent is a person in Florida who can receive formal documentation. Okay. And so if there's a lawsuit, the person who receives it has to be, if you're a corporation, a registered agent. How do you find the registered agent? It's very simple. Any registered agent in the state of Florida, like an association has one, always has to be filed under the Florida Division of Corporations website. Jeff, that's a mouthful. Florida Division of Corporations. I can't even say that 10 times. Well, here's the good news. All you do is Google the word SunBiz, S-U-N as in Nancy, B-I-Z as in zebra. That'll take you to the Florida Division of Corporations website. You search by entity name, and hopefully you know your association's legal name. You type it in, and it'll pop up a lot of public information about your association, officers, articles of incorporation. But the thing you're looking for is the registered agent's name and address. And a lot of people say, hey, I don't need to do that. I know it's the property manager. No, I always say double check, because it doesn't have to be the property manager.
Right. All right. That was great.
That's good information.
That was a pro tip, Jeff. Thank you.
Absolutely. And just going back to it kind of goes to new law. The Florida legislature found that they wanted to give property owners more transparency. And a lot of associations a lot of them don't have websites. They don't have portals. It's just a lot of paper documents. So the state of Florida has now codified a law in a House bill that basically says that if your property has a certain amount of owners, I believe it is far less than what the statute previously required, the association in the next few months is going to be required to have a website, and they're going to be required to post documents online. So one of the things that I would hope that association members or condo owners look forward to, if they don't have a website, is if you live in a relatively larger association, maybe expect in the next few months that you are going to get a website where you can get easier access to documentation.
Jeff, out of curiosity, so let's run this through. You have an association that's required to create a portal or an online access point for the document, and they fail to do so. What happens in that scenario, or what can a homeowner do?
So, right, you have this very important right to give you access to records. Okay, let's say you go through that 3-step process. You Google Sunbiz, you send it out, and the 10 business days come and go. What happens next?
Right.
I don't know what to do, and that's where the power of the statute's pretty important, because whether you live in a condominium or an HOA, you are entitled to ask for penalties. Specifically, in an ironic turn of events, most people think the association fines everybody. Well, this statute gives you the right to fine them. Ultimately, it would be $50 a day for the following 10 days, or $500. On top of that, you would have a legal dispute of a violation of your statutory rights. And I will tell you that this type of legal dispute is a very significant one in the state of Florida. What kind of brings it full circle in terms of the new laws beginning in July of this year, the new laws have now imposed even harder sanctions, which basically say that if the board in a condominium disregards your request and doesn't give you access to the records, there could even be criminal consequences for certain board members down the road.
Wow.
Those things haven't been flushed out yet, but this is a step in the right direction to really hold associations' feet to the fire and making sure that board members who basically run the association are held accountable in a better way.
Agreed.
And correct me if I'm wrong, there's a education requirement as well to make sure that they know what they're getting themselves into, which we've talked about at length. Like, shouldn't there be more? Well,
they occupy such an important role within a community, right? They're managing a very large amount of property values.
Yeah.
And they have fiduciary obligations, and a lot of board members have no idea what they're doing. And, at least in California, there's no real requirement that they educate themselves. They just hop on the board.
Yeah.
So it absolutely looks like Florida is moving in the right direction on so many fronts, Jeff.
Yeah. So starting in July of this year, one of the new House bills, especially as it pertains to HOAs, single-family homeowners, under Chapter 720 now imposes specific educational requirements for board members to understand the laws, understand their governing documents. A lot of people in prior years who were on the board were thinking, okay, I just want to be a decision maker. I don't really have the time to look at these rules and these laws. Look, it's a voluntary, unpaid position. Who has this time? But you know what? I'm going to just be on the board and make sure that my property stays intact.
Right.
Okay. And now what's happening is, because there's been a lot of issues with board members, whether they're been alleged of fraud, embezzlement, abuse of power, the Florida legislature said, no, we can't have this anymore. And so one of the things that it's now done is ensure in a House bill now codified as additional language in Florida Statute 720.3033 has now allowed very strict requirements on what board members need to do to make sure that they're on the up with understanding all of their governing documents. Additionally, condo owners actually have even further requirements in which they need to have a signed certification as well. So and the law prior to July 1st wasn't this way for definitely condominium associations, and it's even strengthened the requirements for HOA board members. So ultimately, at the end of the day, the Florida legislature is really said, you know what, we're going to try to prevent these issues. If you really want to run the board, yes, it's unpaid, yes, it's voluntary, but you got to know what you're signing up for.
I think that's wonderful. I think that's such a game changer, because you're right. I mean, you get motivations which often they can be nefarious. We see it on a daily, in our position. And, if there is an educational requirement, if there's at least some sort of hurdles that someone has to jump over before they get into that position, I think that's a win for the community, because often they step into this position and they have no idea what they're doing, nor do they really understand the contractual obligations, the fiduciary obligations, and the responsibilities. And it's really a position that you cannot take lightly. And it looks like Florida is really reinforcing that, that position.
Jeff, what in terms of the educational requirements, who puts forth the education? Is it the state, or is the state act more like a CE, where they say, well, you have to get continued education, but it has to be through a third party and they have to sign off?
Yeah, is it a private sector? Is it government regulated, or how?
It's government regulated. Usually these educational requirements are hosted by the state of Florida's Department of Business and Professional Regulation, otherwise known as the DBPR, David, Boy, Paul, Robert. And ultimately, the DBPR oversees a lot of disputes when it comes to condominiums and associations. For example, if there's an election dispute, whether you're in a condo or an HOA, any election dispute has to be brought as binding mandatory arbitration through the DBPR. So the DBPR has these arbitrators, but also is able to host these educational requirements. There are some private firms out there that also try to help and supplement the educational information with the DBPR. I think those items are being flushed out right now because this is still brand new law. But ultimately, I believe the state of Florida through the DBPR is regulating those requirements.
Awesome.
Yeah, understood. Thanks, Jeff.
All right, what's the next one you want to tackle? What do we have left on our list?
We glossed over. We didn't. It's funny. Hard.
Say that again.
It's funny because we jumped all over the place because we were so excited about
we hit a lot in sort of a one swoop. So I guess we got to go back. So what have we gone over so far, Jeff?
Well, we've gone over a lot of themes of making sure that homeowners and condo owners are protected. But I do think one area that we need to talk about right now is property managers, because in terms of new law, there is a Senate bill that became law at Senate Bill 382. And 382 really focused on making sure that property managers are held accountable. Okay. And there is a property management statute. I believe it's 453. But ultimately, and there's other language, but property managers in Florida usually have it very good legally, because property managers are agents of the association. And so a lot of people come to us and say, well, my property manager is not responding to me, or my property manager is targeting me. What can I do? Or the property manager just changed and I'm worried that they're not going to have the official records that I believe they have because the property manager wasn't really maintaining them well. Okay. This is where the new law has really helped out, I think, with property owners, because with property managers, there's no longer the excuse from a homeowner or our home association that, hey, the former property manager screwed up, and so we don't have these records. So what happens a lot, or what's happening now, is the Florida legislature said, look, if you're a property management company and you get terminated or your agency agreement is not renewed, you have a duty to make sure that the records that you were overseeing don't get thrown out, don't get misplaced, because that was part of the problem. Hey, a lot of associations go through property managers like turnstiles, and then the association was trying to point the blame somewhere else. So even though legally the right of maintaining these records is the association's legal, non-delegable or duty that they can't give away, they were always saying, hey, look, I know it's our problem, but the property manager screwed up on this. So now the Florida legislature is holding the property manager's feet to the fire, even if they leave, because now they have a statutory duty to make sure that, any records get transferred to the new property management company, so that people can get that level of transparency and communication where what was being lost in the shuffle through a turnstile of property management.
So would it be then the association who would have standing in a situation where the management company lost the records or deleted the records, or who could bring that, I guess, cause of action against the management company? Because I'm sure homeowners would love to do so, but I'm wondering if it'd be most appropriate for the association to bring it.
Well, in that type of dispute, let's just make sure we know that property owners can't necessarily point the blame at a property manager for failing to give access to these records, because once again, not only is this a non-delegable duty for the association, but property owners don't have a direct contract with property managers. So a lot of times we'll hear people say, the property manager is screwed up, or they haven't responded, or the records, the association's pointing the blame. Usually, I will say from a legal standpoint, is a property owner doesn't have any direct course of action against a property manager unless they do something maybe intentional, or there's some defamation going on. But at the end of the day, the property manager is an agent of the association. So if anything, the association might have some legal recourse against property management companies. These statutory protections, they might have a private right of action against property management companies. But clearly this is new law, so it hasn't been litigated yet. But that's definitely, sometimes I say that's a you problem, not a me problem.
Well said.
At the end of the day, I want to make sure that whoever is watching this knows that I'm very excited about the way this wave of new laws in the state of Florida have helped protect property owners' rights. There is more transparency. There is more disclosure requirements. There is more ability to hold others accountable. So I do think that it's all about understanding your rights, and whether they're contractual or rights as whether they're statutory. And that might come into play, especially with statutory rights, because we do see that associations are trying to try to stand away from a lot of these new rights that are helpful. They're trying to distance themselves by informing us, their clients, or associations are trying to think that, well, these new laws don't apply to me. And that's become a really interesting issue that I think maybe we want to get into.
Yeah, that was interesting. So circling back to, you were recently featured on ABC News. Which
Congrats.
It was
Congratulations,
really,
by the way.
Great. The case that they brought up was really interesting because it had to do with some of these newer laws. And one thing specifically that kept coming up, and they referenced it as well, was this term Kaufman language, right? which I found really interesting. But they glossed it pretty quickly. And for a layman like myself, that was okay. It went over, and it's to Jeff's point. A lot of them are trying to circumvent. So how does this all work together, Jeff? What are they doing to try to circumvent this, and how do we hold their feet to the fire?
Well, just briefly, Kaufman has also cropped up in the comments. So we do look at the comments, and I have seen reference to it as well. So I think this would be a great opportunity to explain it and explain your position as it relates to Kaufman.
Yeah. So with a lot of these new statutes that associations just don't like at all, because it is, I believe, turning the tide.
Absolutely.
So associations are saying, well, wait a second. Our contractual documents, our deed restrictions don't have special magic language. Okay. And this is called Kaufman language. What is Kaufman language? Kaufman language is when there is language in a declaration. We talked about this document earlier. In the declaration, Kaufman language usually is that the association allows amendments from time to time, or allows statutory amendments from time to time. Okay, so it basically is saying, look, this is what we know the law to be now, but we don't want to have to revise and amend the declaration and these governing every time. We're just going to incorporate new laws into our governing documents. And so that's what Kaufman language is. It's this special magic language. Where associations are coming in is they're saying, well, lo and behold, our declaration doesn't have this magic special language. Okay, the wizards of transactional attorneys craftily did not include this language. Well, I believe it's a blessing and a curse for associations, because if associations don't have Kaufman language, then that means they don't have to utilize certain new laws, certain statutory laws. But what if those new laws actually favor the associations? The association can't be inconsistent. Why can they pick and choose which laws they apply and which laws they can't? So because the recent statutes are now, I would say for the most part, pushing in favor of owners, a lot of associations say, well, you know what, there's this new pickup truck statute. And the new pickup truck statute says that an association cannot enforce any provisions in the governing documents if they prohibit pickup trucks. Okay? It's a new statute that was amended in Florida Statute Chapter 720, if you live in an HOA. Okay? So what associations are saying now, and what the ABC report was about, was a guy has a pickup truck, and he believes starting July 1st, the association can't do anything about it. And so associations are saying, well, we don't have Kaufman language. The wizards of association law didn't put it in there, so aha. Ultimately, though, I don't believe that Kaufman language is something, it is concerning legally for property owners, but I don't think that just because there's no Kaufman language, that's not the legal end of the story. As if you're a college football fan, there's a guy on Saturday mornings, Luke Carlson, he says, not so fast. And that's the case, I think, here, because even though there's no Kaufman language in governing documents, sometimes with some HOAs or condominium associations, I still believe that there is a process that you still have to go through. So, for example, if a law is procedural in nature, like if voting, if you're going to go through an election and there's a new statute, I'm not saying this is a new statute, but just to give an example that might make more sense to people. If the statute's changed to say, all voting slips need to, instead of white paper, be on red paper. Okay. That's a procedural requirement. And so usually procedural statutes need to be incorporated into association law, regardless of whether there's Kaufman language or not. Okay. If it's substantive in nature, okay, like this pickup truck rule, okay, that's where it takes a deeper analysis. You really have to get into constitutional rights, and you have to get into the intent of the statute as well. And you have to see, does the statute really say, and then say, look, retrospectively, this applies. Or substantively, does this apply notwithstanding whatever it says in the governing documents? And so these are going to be the things that I believe are going to be tested in the future for sure, whether it's a process or procedural argument or statute, or whether it's a substantive statute and it doesn't maybe meet certain thresholds from a legal standpoint. I'm very curious to see how it ends up. But at the end of the day, just because your association doesn't have special magic Kaufman language, don't think that that's the end of the story.
And, you know, our read from California looking into Florida, it seems as if the spirit of Florida right now is really aimed at protecting homeowners, protecting condo owners. And it seems that's really driving a lot of what we're seeing today. And my thought would be, you know, if this was to hit the bench or start to be pressed in the court, it seems that the courts would sort of be in step with the spirit of the law, of where the direction is going, again, to protect the homeowner.
And yes and no. I think ultimately from a judicial standpoint, you got to look at a lot of factors. You got to look at what the intent of the governing document stood for. When people bought into their community, what were they signing up for? When you buy into a community, one of the most important things you got to know is understand in a deed restricted community what they allow and what they don't allow. We find a lot of times we get calls, you know, Jeff, I bought into this condo and I didn't realize until after the fact that it had a two pet limit. And I moved in with 4 pets. Okay. And I say, look, there's only so much we can do about that. But one of the rights you had when you were purchasing was you had the right to access governing documents of the association to know what the restrictions were. So I will tell you, in a climate when there is a lot of selling, especially in real estate in South Florida, buying and selling, a lot of people are saying, well, all these rules are creating a lot of higher special assessments. And so I need out. I need to sell. I need you to understand that if you're going to sell, you're probably going to buy elsewhere. And if you're going to buy elsewhere, you got to know what those deed restrictions are. And ultimately, if you're fully informed about what they allow, what they don't allow, if there's Kaufman language, if there's not Kaufman language, those are the types of questions I would want you, anybody who's watching this, to know about, to make sure that before they actually purchase or enter into a purchase agreement, they understand that these are the things that can be pressured against them. And at the end of the day, I want to make sure that they just make a fully informed decision when you buy. And knowing these rights, knowing your contractual rights in particular, I think is critical, and knowing whether there is Kaufman language.
Jeff, let me ask you a layman's question, because it seems like this is a rather it just feels from a homeowner's perspective that there's such a significant loophole, this Kaufman business, that it almost infuriates me because you're reading the law like, oh my gosh, there's so much good stuff here that helps the homeowners, that ultimately down the line, less problems, less issues.
Right.
It should make everything smoother. So the lack of having this Kaufman language is somewhat bothersome, because it's we found like a little loophole. And I understand the spirit of what it's supposed to be. You bought into this, you want to maintain it. I understand that to a certain extent. Let me ask you this. Can a homeowners association amend their CC&Rs or declarations, I guess it's tomato, to remove Kaufman language in it, so they've now circumvented it completely?
It's a great question, but I will tell you that actually will not be good for an association. And the reason why is Kaufman language is all about future language from time to time as amended. Okay. But if an association amends its governing documents, has a restated, and associations are required or to over time make sure that their governing documents don't expire over time. For some associations, it's a 40-year period, and a lot of these associations are getting older, so they have to renew or amend and restate their governing documents. So if they amend and restate the governing documents, by default, my thought would be they're then incorporating the new statutes. And so ultimately, if your governing documents, you got to look when they were recorded. If they're recorded recently, then any statute that was enacted prior to the date of the governing documents, that is in effect. However, if you have older governing documents and there's no Kaufman language, that's maybe where you have to get into that legal analysis to determine whether they can actually do it or not. And there may be some other strategies I can think of down the road to apply, but just know that in terms of amending and trying to delete Kaufman language, there isn't an aha moment there. Because if you amend a governing document and it's recorded, it by law would, in my opinion, incorporate the statutes that have pre-existed from that amendment.
I like the analysis.
Same.
That's interesting. Jeff, is there anything else that you want to cover on these? Anything specific? Oh, well, I guess one more question. Sorry, because my brain is going a mile a minute. The procedurals that you said specifically for education, can they, even having no Kaufman language, are they still required then to any new board member required to have the educational factor? Would that come under procedural or would that be transactional?
I mean, that's going to be probably a litigated test right there. I guess from my perspective, I would probably say it's procedural in nature. I also would tell you that even if it's not procedural in nature, substantively, I think you could argue spirit of the law, but I think at the end of the day, it comes down to whether it meets certain standards and tests of if the association or if the law intended for these substantive laws to be applied within an association or not. So there's a deeper analysis to it. I'm going to take the position that it should be applied regardless.
And by the way, what a red flag that would be. So your board is up in arms over having to educate themselves as to how to be a better board. That might be telling you a lot if that becomes a fight.
I don't think that would look good in front of a judge or a jury at all. One, I guess, final thing to talk about in terms of new laws, it was actually relating to last year, but it's an issue that I think everybody needs to know, is if you live in a community that that you try to store things in your backyard. Okay, we're finding a lot of issues of people trying to store things in their backyard, like boats or a movable basketball pole, whatever it is. It's summertime. People want to enjoy their outside, enjoy their outdoors. A new law from last year says that an association cannot enforce any penalties against a homeowner on things that they shouldn't have on their property, so long as you can't see it from the front or the side of their properties. And I feel like there's a lot of misconceptions about that because there's been a lot of issues of, well, what does that really entail? What things, what items? And so I would say that if somebody's out there and worried about that, usually I would say it's safer to have something that is movable, not something that's fixed. Like you can't pour a concrete slab of a basketball pole and have the basketball pole up. But if you can't see it from the front or the side and you get a notice of violation or a fine, I believe that your statutory rights might be infringed on. But once again, this then will get into the Kaufman analysis and a deeper dive. So I do want you people to know, because we've been getting a lot of calls and questions about what they can and can't put in their backyards.
Very good.
Well, as always, Florida leading the charge. I love some of this. And just to recap, I'd love I think we'll ultimately do a blog post listing all these things out, but I think it's worth mentioning here. There's 6 bills. So that's Florida House Bill 1203, House Bill 59, 293, 1029, 1021, and Senate Bill 382 that we referenced here today. So if anyone wants to look those up and do a little bit more of a deep dive, I mean, we just glossed just like the very, very surface.
Well, what's interesting now, and again, this show is designed to empower homeowners and, condo owners. And so, if there's any additional information, I encourage everyone, our viewers, to put it into the commentary section. I mean, we look at that, and if there's topics that are pressing that you think is mission critical or things that you would like us to do a deep dive on, let us know. We'd love to have Jeff back on sooner rather than later. It's been a while. You bring so much wisdom to the space, and as I see it, you truly are giving owners power in these situations, and it's tremendous.
I appreciate that, but at the end of the day, I just want people to be more informed. I think that for the longest time, for years and years, there's been this historical kind of infrastructure that associations control all, and it's taken some time, some modernism, and some tragic events that have basically said enough is enough. And I really believe that people need to just know what their rights are, need to be informed, and in communities that people need to be held to higher standards. Board of directors need to be held to higher standards. Neighbors need to be neighbors. And so ultimately, these are places you live, you have to enjoy, your family, you've moved there for a reason. And the reason is most likely because you want to use that property so that you can either enjoy it or use it as rental, as income property. And either way, you want to make sure that it's a community that anyone would enjoy being in. And so at the end of the day, I just want everybody to do their own research. Hopefully they can use a morsel from today to have learned something new. And I always say that as long as you learn one new thing a day, it's been a successful day.
And so, Jeff, I cannot thank you enough. Marty, our producer, thank you so much for organizing and putting this show together.
Oh, this was a fun one. Thanks, Jeff. This is any time that you're on, it's always chock full of so much good information.
It's like the espresso shot of it's so dense of information. I love it. So thank you again.
Absolutely. From South Florida or Florida, it would be a Cuban
there you go,
espresso
with a little
shot,
sugar
but
in it.
Yes. Exactly.
All right. Well, we'll see you again soon. And thank you all for watching the show. Again, leave comments. And what do they say? They say subscribe, hit like.
Hit like,
what do the kids say? Do all that stuff.
All that fancy stuff.
All right. Thanks again.